Hello guys, welcome to another episode of this particular video. As usual, I am Jafet Okaka Ebosetale. So today, under law of contracts, we are going to be looking at acceptance, and we'll also be looking at facts that constitute acceptance, behaviors that constitute acceptance, and behaviors that does not constitute acceptance. So let's first of all define acceptance before going further. Now, you first of all know that acceptance is very crucial as regard law of contracts. Yes, there must be an offer, there must also be consideration, but before consideration there must be acceptance. So let's then look at meaning of acceptance, since it's so important. So let's then look at the meaning of acceptance. This brings us to the case of Orient Bank versus Binati. Orient Bank versus Binati. Now look at the way Nikitobi GCA defined acceptance. Now Nikitobi defined acceptance as the act of compliance on the part of the offeree with the terms of the offer. Nikitobi here defined acceptance as the act of compliance on the part of the offeree with the terms of the offer. So acceptance can be defined as the act of compliance by the offeree. The offeree, who is the one accepting the offer, he agrees to comply with the terms given by the offeror. That is how Nikitobi GC defined acceptance in the case of Orient Bank versus Binati. Then let's also look at the definition in Wakama versus Kalyu. In Wakama versus Kalyu, acceptance was held to be a final and unqualified expression of assent to the terms of an offer. I like this particular definition very well. Acceptance was held to be a final and unqualified expression of assent to the terms of an offer. So it must be final. It's not something like, will you enter into this contract? Will you buy this Bible? Then you say, maybe I'll accept it. Maybe I'll accept the contract. Maybe. No, it must be final. It must be unqualified. There's no other condition to it. There's no other condition. It must be, will you say, yes, I accept to do this. I accept this particular offer. So that's acceptance. It must be final. It must be unqualified. So we'll now also look at the definition of acceptance in the case of Data Steel Limited versus Nigeria Computers. Data Steel Limited versus Nigeria Computers, in which it was held that once there is evidence that a definite offer has been made by one party, it must be shown that the offer has been accepted by the offeree in some final and unqualified terms. This is almost similar to the definition in Wakama versus Kalyu. So let's then look at the definition in Binat International Limited versus Nigeria Deposit Insurance Limited. The definition given by the court in Binati International Limited versus Nigeria Deposit Insurance Corporation. So the court defined acceptance. That the court stated that an offer must be unconditionally and unequivocally accepted. So the court say, for you to say there is an acceptance, that particular offer must be unconditionally and unequivocally accepted. Now what this means is that it must be unconditionally accepted. You will not tell the offeree will not tell the offeror that, okay, you have given me an offer. However, if you do this particular thing tomorrow, I will accept it. That's condition. It's conditional. It's condition. But for it to be accepted, it must be unconditional and unequivocally accepted. This was the definition given in Binati International Limited versus Nigeria Deposit Insurance Corporation. So now you have looked at the definition of acceptance. Then there is a particular question that do arise: is can acceptance be actually can conduct actually connote acceptance? Yes, acceptance must be final. Yes, acceptance must be unconditional. Yes, acceptance must be unequivocal. Must be unequivocally. Yes, but however, can conduct connote acceptance? Can from the party's mode of behaving, can you say there is actually acceptance? The answer to that question is yes. And this brings us to the case of Brody versus Metropolitan Railway Corporation, where the court established that both parties had been acting on the terms of the unsigned documents over a reasonable time. Therefore, acceptance was deduced from their conduct. So, from the party's conduct, you can actually say there is an acceptance, even though the document has not been signed. You can also say there is an acceptance. So, in this particular case of Brody versus Metropolitan Railway Corporation, where there was an unsigned document, a party signs the document, the other party did not sign the document. So there was an unsigned document. So what happened was that, for example, Mr. A is narrow, similar to this particular case. Mr. A will tell Mr. B, Mr. A will tell Mr. B, supply me with 10 bags of cement every month. Supply me with 10 bags of cement every month. Then Mr. B will bring. There's no signed document. There's a particular paper. The contract is there, but Mr. A and Mr. B did not sign this document. They did not sign the document. So that is it. But however, Mr. B will be bringing the bag of cement to Mr. A. Mr. A will pay. Mr. B will bring the bag of cement. Mr. A will pay. That's how it has been going on for months, 6 months, 1 year. Now there's no signed document. However, one day came, Mr. B brought the bag of cement. Mr. B said, lie, I'm not going to pay for this bag of cement. There is no document. It's not signed safe. So I'm not going to pay. So Mr. B instituted an action against Mr. A. So what this court is saying that the court established that the parties' conduct had that the court established that both parties had been acting. They had been acting on the terms of the contract. Though the contract was not signed, but they have been acting on it, and for that reason, it has been accepted. So from their conduct, the court heard that it has been accepted. So it must not necessarily be that it must be signed. Yes, as you can sign it, yes, it will constitute acceptance. It can be oral, but however, from their conduct, you can actually say that this offer have been accepted. So that is it for acceptance. Now, the second question usually asked is whether mere signings can actually constitute acceptance. Can mere signings actually constitute acceptance? That's when Mr. A will tell Mr. B, look, do this particular thing for me. Then Mr. B remains quiet. He say, do this thing for me. If you remain quiet, I will say, you have accepted it. If you remain quiet, I will say, you have accepted this. In that particular scenario, can you actually say there is acceptance? Does mere signings constitute acceptance? Now, in answering this question, this brings us to the case of Faith House versus Binding. Faith House versus Binding. So let's look at the case of Faith House versus Binding. Now, in the case of Faith House versus Binding, the plaintiff made a written offer to buy his nephew's horse. So the plaintiff made a written offer to buy his nephew's horse and stated that if he did not receive a reply, he would assume that his nephew had accepted the offer. So the plaintiff made a written offer to his nephew. He sent it to his nephew, and he stated that if he does not receive any reply, he will assume that his nephew have accepted it. Now that's what it is. See, if you don't answer me, if you remain quiet, if you assign it, I will assume that you have accepted this offer. That's what the plaintiff stated. Now let's move forward. The nephew intended to accept, but took no action to demonstrate this, except that he requested the auctioneer to reserve the horse in question. So his nephew, the nephew of the plaintiff, intended to actually accept this offer, but he took no action. Other than he just told the auctioneer that was going to auction horse, said that horse in question that the plaintiff want to buy, said keep it somewhere. Don't auction this horse. Keep it. Now, it never told the plaintiff that I'm going to accept it all. He never told the plaintiff I'm not going to accept it all. He just remained silent. But rather, he just told the auctioneer, keep that horse in one place. Don't auction the horse. That was what the nephew told the auctioneer. Now let's move forward. The auctioneer forgot and auctioned the horse, and not with others. The plaintiff brought an action against the auctioneer for breach of contract. Now, you remember that the plaintiff stated that if you remain silent, I will assume that you have accepted it. And the nephew actually remained silent. He did not do anything. Rather, he just told the auctioneer, don't auction that horse, keep that horse in question. Now that's silence. He never told the other party whether you have accepted or not. All he just did was to tell the auctioneer, keep this horse in question. And the auctioneer forgot. He forgot about it. He forgot what the nephew told him, and he sold and he auctioned the horse along with others. Now, when the plaintiff noticed that they actually auctioned that horse, and initially I told this my nephew that if you don't accept it, I will regard this. If you are silent, if you don't reply me, I will regard it that you have accepted it. So he did not reply me. Therefore, it means you have accepted it. Since he was signing, it means you have accepted this, and now you have auctioned the horse. There is a breach of contract, so he instituted an action in court. That's what the plaintiff did. Now, what did the court say? Does mere silence constitute acceptance? Now, what did the court say? Now, let's look at what the court held. It was held that there was no binding contract. In that, at the time the horse was sold, there had been no valid acceptance by the nephew. The court held that there was no binding contract. At the time the horse was auctioned, there had been no valid acceptance. There had been no valid acceptance. There was no valid. It was the acceptance that was not valid. There had been no valid acceptance. That's what the court held. That is to show that mere silence does not constitute acceptance. So this is it for the general introduction into acceptance. Subsequently, we'll be looking at acts that we'll be looking at ineffective mode of accepting an offer subsequently. So this is just a general brief introduction into acceptance. Thank you so much for watching. By name as usual, I am Japhet Okaka Ebusetani.